Hello, this is my weekly news roundup for the week of 3rd of May 2021, with thanks to Legal Futures, the New Law Journal and the Law Society Gazette. Sex Matters campaigner Maya Forshtata took a case to the Employment Appeal Tribunal last week. She claims she was dismissed for expressing the view that sex is a binary biological matter and not something people can choose. An employment tribunal ruled that her opinion was not protected under discrimination legislation because it wasn't worthy of respect in a democratic society. The appeal judgment is expected later in the year, and you can look at the Sex Matters Twitter feed, link below, for a detailed account of the arguments on both sides. Separately, the Employment Appeal Tribunal upheld a ruling that a well-known firm did not fire its chief executive because he made protected disclosures about financial problems that were discovered at the practice. Rather, it was because he resigned almost immediately after the problems were found, running for the hills, as the firm's founder put it, without staying to see the real extent of the problems. We're 2 months away from the start of the new Whiplash regime, supposedly so easy that claimants don't need lawyers, and yesterday the user's guide was published for them, a mere 64 pages of guidance. If you have a basic claim with an injury that falls within the tariff and there's no contest over liability, it should be easy enough. But as soon as you throw in a non-Whiplash injury, or credit hire, etc., it's going to get tough. Legal treacle is how one observer described the guide. Again, there's a link to more details below. Meanwhile, the Court of Appeal in Re F overturned the refusal of a mother's application to adjourn a 10-day final hearing in care proceedings on the ground that she would then be 8 months pregnant and unable to take a fully active part in the proceedings. If a pregnant woman feels unable to attend shortly before her due date, a court should not, said the Court of Appeal, adopt a wait-and-see approach or force the woman to bring medical evidence that attendance might cause difficulty. In a landmark case, the Court of Protection has ruled it is lawful for care workers to help those with disabilities, in this case a 27-year-old man with autism, visit a sex worker. The issue turned on the meaning of whether a carer who gave such support would be intentionally causing or inciting a disabled person to engage in sexual activity. That's prohibited under Section 39 of the Sexual Offences Act 2003. Whilst describing the ethical issues as complex, the judge held it wasn't unlawful. Finally, the Bar Tribunals and Adjudication Service has proposed significantly tougher sanctions for barristers who commit sexual misconduct after it faced criticism for being too lenient. A consultation document suggests that penalties for sexual misconduct should start at a suspension of over 12 months, which contrasts with recent decisions where those found to have committed inappropriate sexual conduct in a professional context received a reprimand or a medium-level fine. Thank you to Legal Futures, to the New Law Journal and to the Law Society Gazette for allowing me to reproduce their content. Links to those publications and websites below. Thank you so much for watching. This is a video I think you might enjoy, and please do subscribe to this channel. I'm Barrister Daniel Barnett. Bye bye.